Thank you. You'll be relieved to hear that I've only got 4 minutes and it's got no legal content whatsoever. It's something that's quite interesting that's come across my desk over the last 18 months. I'm sure many of you will have businesses where you're highly regulated or you see EU regulation coming down the pipe, which may well affect your business. And barely a day goes past nowadays without reference in the newspapers to either new EU directives or e-cigarettes. In this case, I've got links to the two. Effectively, our client is a major retailer and manufacturer of e-cigarettes, and it appreciated some time ago that there was the Tobacco Products Directive on the horizon, and much has been made about the provisions in that directive affecting normal tobacco companies. But hidden in there were provisions in relation to e-cigarettes. And the client appreciated the consequences of those proposed articles were going to be very dramatic indeed and would potentially really damage not only our client's business, but also damage the e-cigarette business. And you'll know that this debate is ongoing at the moment about whether e-cigarettes are good or bad. Those in favour say actually they're an amazing aid for those who are smoking to either quit or to reduce their tobacco consumption, which everyone knows that it can be very harmful to your health. So we looked at this directive, and our client retained a lobbyist who worked very hard with the MEPs, and we managed to get the MEPs on board, and there were very significant changes to the proposed directive at the 11th hour. And the result of those kind of closed room negotiations at the 11th hour meant that there was a revised Article 20 in relation to e-cigarettes. However, on close analysis, that article is regarded by our client as still very unsatisfactory because it considers that it puts unnecessary restraint on the ability of our client to advertise and to sell and to promote. So they asked us to consider whether there was anything that we can do. Now, one may question this and say, well, how can you go against the will of the European Parliament and the 28 member states? But EU institutions are not just able to do whatever they like when passing laws. They do have to comply with legal principles laid down in the EU treaties and conventions when they are formulating law. And so where the legislation appears to breach these principles, there are ways in which you can challenge that. The difficulty is that it's not just a straightforward case of going to the English courts and saying to the English courts, look, this piece of EU directive that's going to be implemented into the UK is unlawful because it breaches the EU conventions and treaties, because the UK courts do not have the power to regard an EU directive as unlawful. But what we managed to do was to try and circumvent that and get in by the back door, as it were. And that is because, as I'm sure you're all aware, when you get an EU directive, for it to operate in law, in England, you have to have the UK implement that. And so what we have done is make an application for judicial review in the UK courts and asserted that the Secretary of State for Health's implementation of that EU directive, and in particular Article 40, is unlawful because that provision contravenes some basic principles of the requirements for EU law. And what there helpfully is a window of opportunity to be able to make that challenge, because the European Parliament approves the directive, and then there is a 2-year period in this case, and frequently is a 2-year period within which the domestic or their own member states have to implement that directive into their domestic law. And so within that 2-year period, we've gone for expedited judicial review. And the judicial review resulted in the domestic courts referring the question of the legality of this article to Europe. And we have sought for it to be expedited, and we hope to get the answer well before the time within which the directive has got to be implemented within the UK. And if the decision in Europe is that the article does breach these requirements for EU law, then we're hopeful that it will go back. It may or may not, murmurings within Europe of legislation that actually could have some far-reaching consequences of your business, I think that it's important to act quickly, to consider whether you should get lobbyists lined up, and if all else fails, there may well be a basis on which you can challenge that legislation before it applies directly to your business. Thank you.